However, if it's unsuccessful, the next step in the claim process is arbitration. And arbitration in these documents is mandatory and it is binding. Another timeline that's involved in these AIA documents has to do with the payments to the contractor. And this is written out in many, many paragraphs, but it's very simple. Again, the time moves from the left to the right. There's going to be a date set in the contract when payments are to be made. Let's say we chose the 15th of the month. So every 15th of the month, the payment is supposed to be tendered to the contractor. But in order for that payment to be made, some things have to occur in advance of it. And the first thing that has to happen is we have to apply for the payment. And so the rules of the AIA documents say that we apply for these payments 10 days prior to the due date set in the contract. So if we set the contract on the 15th, the due date on the 15th, the contractor must apply by the 5th. Now, after that, the architect has to have time to review the contract and review the payment request and make sure all is in order. And the architect is given 7 days to do that. Now, once the 7 days is over, the owner has 3 days to pay. Now, it doesn't matter who is specified as having to cut the check. If there was a bank involved here, the bank would have 3 days to pay. But the bottom line is that the date is set in the contract. 10 days before the due date, the contractor applies. The architect has 7 days to review it, and the owner has 3 days to pay. Another exhibit you have in your package is labeled Bid Timeline. And this is meant to go with AIA Document 701, the instructions to bidders. And once again, this timeline moves from the left to the right. And it'd be a good idea if you compare your outline with the timeline and look at the AIA documents and write in the exact dates involved. It'll help you see the sequence. The first step of this process is the bid is announced. Now, this announcement will have instructions to the bidders as to how to proceed. And a complete package of bid documents would be assembled for this purpose. A deposit might be required for the bid package to be released by the owner. And considerations such as a consideration with Davis-Bacon might come into play here. As you may recall, Davis-Bacon is an employment regulation and has to do with the labor rates that are paid on federal jobs or jobs that are done with federal dollars. Essentially, Davis-Bacon requires us to do 3 things. The first thing is we have to classify everybody in our organization by what category of labor they represent. And there's no allowance for gray areas. The person is either a laborer, or he's a foreman, or he's a carpenter, or he's a flagman. You have to classify everybody appropriately. The second step is you contact the regional office that governs your area, in our case it's Atlanta, and determine what the prevailing wage rates are for each classification of person in your organization. And then the third thing is, based on these rates, you have to pay your people in accordance with these classification rates, and you have to document this by actually turning in time cards, well, they're forms that parallel time cards, showing the classification, the hours that were worked, and the amount paid, to show that you are conforming with paying to federal regulations. Site inspections or meetings may also be a part of this process. Now, the bid announcement is going to go forward, and the first deadline that's going to occur are any kind of deadlines for requests for additional information or for clarifications of one kind or another or for deletions or substitutions. And if you'll notice in your outline, it indicates that copies or clarifications must be done 7 days prior to the date set for receipt of bids. Now, the word receipt of bids is the deadline for turning in the bids. And so we have 7 days before that we can ask for clarifications. And under your outline 3A4 substitutions, we have 10 days prior to this date for suggesting substitutions. So we have these 2 deadlines to deal with prior to the turning in of the bids. Now we turn in the bids, and the bid opening may be the same day we turn in the bids, or it may not be, but there'll be an official date where the bids are actually opened. Then, of course, there'll be the reward of bid, and you recognize that there is nothing in the bidding process that indicates that the low bidder must be accepted. In federal or open bid jobs, it is what is called the lowest responsive bidder, and responsive can relate back to qualifications and other more subjective ideas. Also, there is, after the award of the bid, or when an individual wants to withdraw from the bidding process prior to the date of the bids being open, An individual may want their deposit back, and so there's a deadline for the bid deposit. And once the bid is awarded also, there will be a time frame where bond information will be required in the documents. Now, what's going to happen at this point, assuming that everything is fine, the individuals involved are going to sign either the 401 if they're subs or a 201 if they're the GC. And at this signing or several days thereafter, they will have to provide the documentation that goes with these documents. Insurance documentation, a schedule of values, a critical path method, a list of acceptable subcontractors. And inherent in this process is also what commitment is being made for the end of the project. At the end of the project, a commitment is made that all applicable legal documents are turned over to the owner, that all final releases of liens from anyone who filed a notice to owner is turned over to the owner, as well as the final release of lien from the contractor. And then there is a project manual that's normally provided, which has a complete history of the project for future reference for warranty concerns. And in looking over this bid outline, I think you'll get an idea of how the bid process is designed and how it flows, and you're going to need to be able to isolate these time frames for the exam. Another exhibit that we want to take a look at a little more closely is the G702, and the G703, which is the application for payment. And this is a two-page document consisting of a first page, the certificate for payment, and what is called a continuation sheet. And you'll notice that I've just lined up these two pages so we can go back and forth with one another. If you'll take your two examples out from your state reference books, you'll be able to follow this along fairly easily. Notice on this continuation sheet, and this is where our story begins, you're going to be expected on the exam to answer some questions about payments. And the easiest way to do that is simply to understand how this sheet operates. And in fact, this is a very excellent way to manage your process as you contract. You have to start with the second or continuation sheet, and notice there are rows and columns. And in these various columns, A, B, C, and so forth, you have different items. For example, column A is item number. That's pretty relevant. Column B is a description of the work. And column C is a scheduled value for the work. Now, what's important about this scheduled value is this is how the contractor has chosen to proportion the value of the work. And if you were to list out the items in column C and the scheduled value for each, when you added them up, they would equal the original contract sum, which is line 1 of the first page. So whatever the tally is from C is going to go directly into line 1 of this application for payment. Now, lines D, E, and F, as well as G, all tell a picture of how this project is moving forward. And you really have to understand clearly what the difference is of these different columns. And it's not that hard because it stands to reason. We start out here looking at item or column D. And notice that it tells us that both D and E are in a zone referred to as the work completed zone. Well, if I wanted to know work that was completed on a project, the first thing I might want to know is, well, what have we done before this point? And this is D, work from previous applications. Then I might want to say, well, what work have we done in this period? And that is this column, this period. So any application is going to show a running tally of everything that I did before, plus everything that I am doing now. In addition to that, F here indicates that in the AIA documents, if materials are not installed, but they are present on the site, you are allowed to get paid for them. And so F is saying, look, in addition to work we have completed, either in the past or in this period, we also have materials that are stored on the site, even though we haven't installed them. And F gives us an opportunity to quantify this and to be paid for it. Now, G is simply an addition, a tally of D, E, and F. In other words, G, which is the total completed and stored to date, is telling you everything that was done before, everything that's being claimed as far as work goes in this period, and everything that is being stored in this period as well. And so if we add up D, E, and F, we get the total value, the total completed and stored to date. And this G, once added up, is going to go on line 4 of the first page on the total completed and stored to date. You'll notice also that within G, they say G divided by C, and that is giving you the percentage of completion. And we're going to deal with these percentage of completion calculations in the next module. H is indicating what's the balance to finish, and that would be simply C, the scheduled value, minus G, the value of everything in place, and I would be a tallying and a recording of the retainages as we go along. Once we have filled out all of these different columns and tallied them to the bottom, we're going to take the information from the columns, and now we're going to go through our payment cycle, our calculation of payment cycle. And now we'll pay attention to this first sheet only, because we have already tallied up all of the second sheet. The way we read this first sheet is, first of all, we have project information listing here on the top. And then we're going to have a place where the contractor will sign, and then a place for the architect to certify. And if there were change orders in this process, we would be recording these change orders in this little box here that talks about change orders. And what's going to happen is, number one, we're going to write down the original contract sum. And if you remember, that was the total of the scheduled value. And number two is, well, there have been change orders here, so we're going to take the summary of what's happened with these change orders and the dollar value of these change orders, either plus or minus, because change orders can also subtract from value. And we're going to indicate the net change by these change orders, which will lead us to 3, which is the contract sum to date. The original contract changed by change orders now is what we are dealing with now. Number 4, however, comes off the second sheet. Number 4 is the total completed and stored to date, and represents everything that's in the field for which payment is to be made. The next step is to subtract out any retainage. Now, it doesn't matter whether we're in the first draw or the last draw. We're going to go through this process exactly like this. We're going to find out what the total value of all the work in place is as of today. We're then going to subtract the retainage amount from that. And this will give us the next line, which is the total earned less any retainage. Now, the total earned less any retainage is the total amount of money that is supposed to be given to the contractor from day one to the present. So number 7, there may have already been payments made to the contractor from previous applications. And so we're going to subtract these payments, and what is left over is the current payment due. Then finally, we are going to indicate how far we have yet to go, our balance to finish. If we were to take information and just plug it in these pigeonholes, we would be able to come out with the current payment due or any other number that is being requested for on the exam. Now turn to the next page of your outline, and you'll see Roman numeral 3, which deals with the lien law. Now, the lien law is described in Chapter 9 of your Contractor's Manual. So take out Chapter 9 of the Contractor's Manual and take a look at the first page table of contents. The table of contents here is not very exhaustive, and you may find the reading of this chapter a little difficult to follow. However, the important points are that we are going to be talking about a process that is separate from filing a lawsuit against somebody. The lien process is considered an extraordinary process. And if you look at the first page of this chapter, where they go into the text of the chapter, Construction Lien Law, they're going to point out in this first page that the lien law is an extraordinary remedy. Because it allows one person to make a claim on another person's property. Because it's an extraordinary provision, it has very specific steps that have to be followed. And it is a statutory process. That is, these steps are laid out in the statute. In this Chapter 9 in your book, they also give you an exhibit of the statute. So you have the commentary, and then you have the statute itself. And you can either use the commentary to help you to mark your books and to indicate what steps are required and what the timelines are. Or you can look at the statute to mark the same things. One feature also of the lien law is that it's necessary to be able to add and or subtract time. And keep in mind that adding time simply means, or the word from simply means to add. So today is the 3rd, and I say 2 days from today is the last day I can do something, the answer is the 5th. If today is the 21st, and I say 5 days from today is the last day I can do something, the answer is the 26th. Now, if a deadline falls on a Saturday, Sunday, or holiday, if after I, for example, have added 6 days and I find out I'm on a Saturday, Sunday, or holiday, then I get to extend it to the next business day. Okay? So from means add. In the same way, the phrase prior to means subtract. If today's the 15th and I say 5 days before today, the answer is the 10th. If today's the 9th and I say 4 days before today, the answer is the 4th. And where you might have to practice this a little is where months cross over from one to another. For example, if today was January the 2nd, and I said 3 days before today, what day would my deadline be? Well, 1 day before January the 2nd would be January the 1st. 2 days before January the 2nd would be December the 31st. And 3 days would be December the 30th. So 3 days before the 2nd of January would be the 30th of December. If you practice this a little bit, it'll become pretty easy. And then when you have to add larger numbers, such as 45 days from a particular event, it will be easier and easier for you to do this. Okay? Also, again, when looking at any law, and this is certainly no exception, you have to consider what is this whole law about, who does it cover, and what happens if I don't do it. And as you go through these rules, you want to get that sense. Now, to best explain how this works, we're going to invite you to take a look at an exhibit in your workbook that deals with liens. So open up to that exhibit, and let's go through this process in terms of the concepts, and then in terms of the time sequencing involved. One of your exhibits is listed as lien law concepts, and the word privity is written up at the title of this. And the word privity has the same root as the word private. And as we explore the lien law, the first concept that we have to get clear in our mind is what is meant by this by this word privity, and how does this affect the lien law relationship? Now, this entire discussion is all about who has the right to place a lien, and under what circumstances they have this right to place a lien. And there are people that are in privity and people that are not in privity. And whether you are in privity or not in privity, you may have a right to lien. But the issue here is what precisely must you do to make sure that you have a right to lien? Now, I've drawn this little diagram here to help you, and you'll notice also in a moment we'll turn to, there is a diagram in your lien law chapter in the Contractor's Manual. I think if you see our diagram first, their diagram will look a little more clear. The contract begins here with the owner. And you'll notice that the lines with the arrows are establishing the relationship, the contractual relationship between the parties. So what I'm trying to show you here is that the owner has signed a contract with either or all, a contractor, an architect, or an engineer. But the point is that the owner has signed a contract with these folks. This owner now is in privity with these individuals by virtue of the fact that a direct contract was made between the owner and any or all of these individuals. Now, what this means is very simple. If you're in privity, then you do not have to do anything to have a lien right. You automatically have a lien right. Now, once you've established this right, then you must follow the rules of the game in order to claim your lien. But the issue here is what right is established, and what right do you have to claim a lien? And those people that are in privity have an automatic right to claim a lien. They do not have to do anything else to have the right to claim a lien. Now, if they want to claim a lien, they have to go through the dance steps. However, many times in contracts, there is a preliminary contract between an owner and one party, and then there are other contracts that flow from that party elsewhere. For example, the contractor may hire a subcontractor, or maybe the contractor hires an architect, or maybe the contractor hires an architect and an engineer. Well, in this case, the contractual relationship is between these folks and the contractor, and these folks are not directly connected with the owner. In the same way, any of these folks could order materials for this job, and the supplier here would also be outside of a direct contractual relationship with the owner. Well, these folks are said to be not in privity. And what that means is that they do not automatically have a right to file a lien. They must do something first. They must formally tell the owner that they exist and that they intend to do something if they're not paid. And that formal announcement is called a notice to owner, a notice to owner. And anybody that's not in privity must file a notice to owner within a deadline, or they lose their right to lien. Now, this deadline is twofold. They have to file the notice to owner within a time frame of 45 days from first furnishing their labor or materials. But there is an exception to this. What if, for example, You started doing work and you finished doing the work, but before you had a chance to file the notice to owner, the contractor claimed that you had been paid and received a final payment from the owner. In this case, the owner acted in good faith because there was no record of your claim. And the owner, being presented by the contractor's sworn affidavit that he has paid everybody, would have no reason to suspect that there was anybody that had not been paid. So if the contractor goes before the owner in advance of the filing of the notice to owner by the sub, and the contractor in a sense lies and says that he's been paid when he is not, but the owner has acted in good faith and pays the contractor, then that subcontractor cannot now come back and say, hey, wait a minute, I have the right on your property, Mr. Owner. I can claim a lien. The owner acted in good faith, and the lien law issue is between the owner's property and everybody else. Well, what about the poor sub? Now the sub is out the money. Well, that's true. What remedy would the sub have? Well, the sub could go back after the contractor, but would not be able to go after the owner's property. So the first issue in the lien law relationship is whether a person is in privity or not in privity. If they're in privity, they have the right to lien. If they're not in privity, they do not automatically have the right to lien. They must do something first. They must file a notice to owner first. In your contractor's manual, you have an exhibit. Depending upon the edition, my page 9-11, this is Chapter 9, the lien law. And this chart is attempting to explain and show visually this idea of in privity and not in privity. And you'll notice here that it starts out with the owner, and everybody that's got a direct line connected with the owner is somebody that's in privity. Now, if these people are in privity, they have the automatic right to lien the property. And you'll notice here the owner is contracting with a contractor as well. Now, with respect to certain particular individuals, for example, the architect, the engineer, mainly the architect and the engineer, these people have what is regarded as professional status, and they're treated a little bit differently in the lien laws than others. And the principal way in which they're treated differently is this. This architect and this engineer contracted with the owner, and they may have provided services to the owner. And these services were provided whether the thing they were working on ever gets built or not. So we could have a situation where the owner engaged the services of these folks, but the subdivision never went forward. And the argument might be, well, gee, they don't have the right to lien because there was no work involved in the field. However, if these professionals are directly connected to the owner, and if they have performed their work, whether or not any work actually gets done in the field on the project is irrelevant to their right to claim a lien. Another feature here is, if we take this situation a different way, is here we have the architect who has now hired an engineer. Okay? And this engineer, who has been hired by the architect, by this line, is he shown in privity or not in privity? Not in privity. Which means that this engineer would not be able to file a lien if the property was not actually improved. But if the property is improved, and if the engineer follows the correct protocol for filing the notice to owner, then this engineer would have a claim of lien. Down at the bottom of this line, you see an engineer who is out of the loop completely because the property was never actually improved. In other words, the architect contracted with the owner. The architect turned around and hired this engineer down here, but the property never got improved, so this engineer would be out of luck.